Did you catch that? Did that really just happen? The moment I saw this exchange from a Senate confirmation hearing, I knew we had to watch it together. I had only seen a few clips floating around online before sitting down to watch the full exchange, and I kept hearing people say Senator John Kennedy absolutely dismantled this judicial nominee. So I wanted to see for myself whether the viral headlines matched what actually happened. As we go through this, I want you to pay attention not just to the questions, but to the answers. Sometimes in these hearings, the most revealing moments aren't what gets asked. They're what someone struggles to answer. Before we jump in, welcome back to the Political Brief, where we break down the biggest stories in American politics from across the country. If you enjoy honest political commentary and congressional hearing reactions like this one, make sure you subscribe, turn on notifications, leave a like on this video, and drop a comment below telling me what stood out to you the most. I read your comments, and I'd love to know whether you think Senator Kennedy was asking fair questions or whether you think the nominee handled herself well. All right, let's get into it.
Judge, welcome.
Thank you.
You are probably the least productive member of your district court, isn't that right?
Well, I have not considered myself in those terms, Senator.
Well, let me explain what I mean. You have 125 motions pending that you've declined to decide.
Let
me finish. That's more than any other district judge in the entire Seventh Circuit. In fact, you rank 7th highest nationally, do you not?
I am not familiar with those statistics, Senator Kennedy.
You haven't looked?
I did look in preparation for this hearing, but I didn't compare myself to others.
You haven't seen that you ranked the 7th the worst in the country in terms of making decisions?
You are the first to tell me this. And I think for me, I stress the quality of my decision-making. And as I explained, I was the first district judge to come on during this administration.
Yeah, but so were all the others. I mean, there have been 68 district judges confirmed in the 117th Congress. In terms of motions pending for more than 6 months, you rank number 3. You all came on at the same time. You all had the same problems with COVID. You're the 3rd worst. You really think of all the other district judges in the 7th Circuit, you're the one that ought to be promoted based on this record?
Senator, this is something that I've discussed with my fellow judges. Many of us new judges from...
I thought you said you'd never looked at these statistics.
I haven't, these particular statistics I am not familiar with. But in terms of new judges, both from the current administration and the former administration, we are quite a collegial bunch. And oftentimes talk about the pressures of a new judge and the way reassignments work in our district, which is that you get, for example, 300 cases.
Yes, ma'am, I understand. I'm familiar with the procedure in federal court. Here's what I'm trying to understand. Why is your record so bad?
Well, I don't view it that way, Senator. When I look at the quality of my decision-making, the feedback that I get from parties,
Of course parties are not going to criticize you. They want you to rule in their favor.
I understand, Senator Kennedy.
I mean, that's just the way it works. Help me understand why you have such an abysmal record in moving cases. I mean, it costs a lot of money to litigate, and people are paying lawyers, and time is money. And of all the district court judges in the 7th Circuit, you're the worst in terms of moving cases. Why do you think you deserve to be promoted over all of those others?
So, Senator, again, I'm not familiar with the statistics, but I stand by my record and that I give parties what they need. I think, I am regularly in my courtroom. I am regularly issuing decisions. I just came on at a very difficult time where there was a backlog in the courts.
So did everybody else. Let me ask you, when you were a partner in your law firm, you volunteered to write a brief on behalf of the Brady Center. You wrote the brief, and this is what you said. You volunteered for this. You weren't being paid. Is that right?
This was a pro bono case that one of my partners brought in, yes.
You said, quote, assault weapons may be banned because they're extraordinarily dangerous and are not appropriate for legitimate self-defense purposes, close quote. Tell me what you meant by assault weapons.
Thank you, Senator Kennedy. Just to clarify there, I was local counsel. Our Supreme...
Yeah, but you wrote the brief. Tell me what you meant by assault weapons.
Senator Kennedy, actually, I did not write the brief. The brief was written by...
You signed the brief, though, didn't you?
Correct. I signed the brief.
When you sign a brief, you're testifying to the court that everything in it is true, right?
Yes.
Okay.
So
they're your words in terms of the court, right?
Well, you're correct, Senator Kennedy. Okay. I would never sign...
Tell me what you meant by assault weapons.
So I am not a gun expert, and at the time, that brief, I think, was about 10 years...
But you were giving the court advice about, say, ban assault weapons. What is... You told the court you were an expert. Just tell me what you wanted to ban.
Senator, sitting here today, as I said, I did not write that brief. I was local counsel.
Sign the brief.
I understand. At the time...
Tell me what you wanted to ban. That's all I want to know, Judge.
I don't remember the exact definition of assault weapons in the ordinance that was at issue.
So you submitted a brief to an appellate brief, you signed it, and you don't know what, and you said abolish assault weapons, and you don't know what you wanted them to abolish?
Senator, at the time that I signed the brief, I read the brief because our Supreme Court required an Illinois bar member to sign the brief. I was not responsible for researching the content.
You were responsible for the brief.
Absolutely, absolutely. And sitting here today, I do not remember the characteristics of that were cited in the ordinance for the assault weapons ban. It's not an area of practice that I have specialized in. I'm sure 10 years ago I could have answered your question.
And
but
Judge,
sitting here today,
you think you deserve to be promoted? With this record?
Senator, I stand by my record. I stand by my record.
Senator Butler.
Thank you, Mr. Chairman. Congratulations to you and your...
Right away, Senator Kennedy comes out with a statistic that completely changes the tone of the hearing. Instead of asking about legal philosophy or constitutional interpretation, he goes straight to the nominee's record as a district court judge. His argument is simple. Before someone gets promoted, their performance where they should matter. He says she's among the least productive judges in her circuit based on pending motions that have gone undecided for months. That's a serious criticism because delayed rulings don't just sit on paper. They affect real people. Businesses wait. Families wait. Criminal defendants wait. Victims wait. Civil lawsuits become more expensive. Justice delayed can become justice denied. Now, the nominee responds by saying she focuses on the quality of her decisions rather than comparing herself to statistics. That's a reasonable point on its own. Every judge should care about getting decisions right, not simply moving cases as quickly as possible. But Kennedy doesn't let the issue go. He keeps coming back to one question. If everyone else faced the same challenges, why is your record different? That's really the heart of his argument. He points out that other judges were appointed during the same general period, dealt with similar pandemic-related backlogs, and managed to move cases more quickly. Whether you agree with his conclusion or not, it's a fair line of questioning during a confirmation hearing because senators are evaluating qualifications for a higher court. What struck me watching this wasn't necessarily the statistics themselves. It was how difficult it seemed for the nominee to directly address them. Several times, she said she wasn't familiar with the rankings or emphasized that she stands by her record. That's certainly her right. But politically, those answers didn't seem to satisfy Kennedy. He kept narrowing the discussion back to one central issue. If these numbers are accurate, why should the Senate reward that record with a promotion? That's the kind of exchange that often goes viral because viewers naturally compare the questions with the responses and decide for themselves who made the stronger case. Then the hearing shifts to another topic that has become incredibly important in judicial confirmations, the Second Amendment. Kennedy brings up a brief she signed years earlier in support of restrictions on so-called assault weapons. Now, it's important to be precise here. The senator is referring to a legal brief from years before her judicial service. He asked what she meant by the term assault weapons as used in that filing. Her response is essentially that she was local counsel, she signed a brief, but she doesn't remember the specific definition that was used in the ordinance at issue. Kennedy clearly finds that answer unsatisfying. He presses repeatedly, asking how someone could sign a legal brief advocating restrictions without being able to explain what the term referred to. From his perspective, he's testing whether she fully stood behind arguments submitted under her name. From her perspective, she's explaining that she wasn't the principal author and doesn't remember the exact details of a decade-old case. Those are two very different ways of looking at the same exchange. Watching this unfold, I can understand why this portion of the hearing has generated so much attention online. For many conservatives, judicial philosophy matters just as much as legislative policy because federal judges often serve for decades. They interpret constitutional rights that affect millions of Americans long after presidents and senators leave office. That means confirmation hearings aren't just about resumes. They're about judgment, preparation, and how nominees explain their past positions. One thing I always try to keep in mind when watching these hearings is that they're inherently adversarial. Senators ask difficult questions on purpose. Nominees prepare extensively, but can't anticipate every detail that might come up, especially from work done many years earlier. That doesn't automatically mean either side is right. It's up to viewers to weigh whether the answers adequately address the questions. Personally, I think Kennedy's questioning was effective because it stayed focused. Rather than bouncing between unrelated issues, he returned repeatedly to two themes: productivity on the bench and accountability for prior legal advocacy. Those are legitimate topics for Senate oversight, and regardless of political affiliation, nominees should expect detailed scrutiny of both their judicial performance and their legal record. At the same time, it's also fair to recognize that judicial workload statistics don't tell the entire story. Different cases vary enormously in complexity, and there can be many reasons why some motions remain pending longer than others. A statistic by itself doesn't necessarily establish that a judge performed poorly, though it can certainly prompt senators to ask tough questions about the record. The same applies to legal briefs. Attorneys often work collaboratively, and local counsel may have a different role than the primary authors. Even so, that's why hearings like this matter. They allow the public to hear not only the senator's concerns, but also the nominee's explanations. Whether those explanations are persuasive is something each viewer has to decide. One thing that's undeniable is that Senator Kennedy has developed a distinctive questioning style. He often relies on straightforward, repetitive questions that are difficult to sidestep, and when he believes he hasn't received a direct answer, he tends to ask the same question in different ways rather than moving on. Supporters see that as holding officials accountable. Critics sometimes argue that his style can be confrontational or overly theatrical. Either way, it often produces memorable exchanges that attract public attention. As I watched this hearing, I kept thinking about how much these confirmation battles reflect larger debates happening across the country. Americans increasingly expect judges to interpret the Constitution faithfully while also managing heavy caseloads efficiently. Senators, meanwhile, are tasked with evaluating whether nominees meet that standard before receiving lifetime appointments to higher courts. That's why these hearings receive so much scrutiny. They're not simply about one individual. They're about the kind of judiciary the country wants. Now I want to hear from you. After watching this exchange, do you think Senator Kennedy raised fair concerns about the nominee's judicial record and previous legal advocacy? Or do you think the nominee adequately explained her positions under difficult questioning? Leave your thoughts in the comments below. If you enjoyed this breakdown, don't forget to like the video, subscribe to the Political Brief, and share this video with someone who follows American politics. Thanks for watching, and I'll see you in the next one.